Hi everyone, my name is Judy and I'm here with Rebecca and Alan, and today we're going to be talking about the history of disability during the Civil Rights era 1960 to 2000. So the Civil Rights Movement was a catalyst of change for people with disabilities. The national discussion of civil rights sparked the conversation about the rights of those with disabilities should and would have. The Civil Rights Act of 1964 left out those with disabilities. President Kennedy had a major influence on those with disabilities. He signed the Maternal and Child Health and Mental Retardation Planning Amendment to the Social Security Act, which ended up giving grants to help states update their intellectual disabilities programs, which then led to research centers being brought about, more university-related diagnostic treatment clinics, as well as more community-based centers for those with disabilities. The Elementary and Secondary Education Act in 1965 also helped toward the progression for those with disabilities. It brought education into the forefront to provide equal access to quality education. The 1969 amendment was dedicated to the education of individuals with disabilities. We see further progression from this act. In 1970, U.S. schools educated 1 in 5 children with disabilities. Almost 1.8 million children with disabilities were excluded from instructional programming prior to the EHA. The founding of the Special Olympics went to show more progression towards those with disabilities. The inaugural games were held in Chicago with 1,000 athletes from the United States and Canada. And today there's over 500 million individual athletes participating and over 100,000 activities a year around the globe. An important case during this time period was Larry P. versus Wilson Riles in 1971. It ruled that the district was banned from using IQ tests to place African Americans in EMR or special education settings. This was significant because it highlights the disproportionately high minority enrollment in special education programming.
Mills versus Board of Education in 1972 was an influential court case which granted parents the right to be involved in educational placement decisions for their children and the right to be notified of evaluations, placement, suspensions, and when service terminated. This laid the foundations for both families and stakeholders to be more involved in the education of students with disabilities. Another case was Park versus the Commonwealth of Pennsylvania in 1972. In this case, the state agreed to provide access to free public education for children with MR up to the age of 21. It also established a standard of appropriateness that each student should receive education to their learning capability. This overturned a law in which a public school denied services to children who had not attained a mental age of 5 before their first grade enrollment. Section 504 of the Rehabilitation Act was passed in 1973. It was the first disability civil rights law to be enacted in the United States, and it protects those with disabilities against discrimination from financial assistance programs and from exclusion and unfair treatment in schools, in their careers, and in the greater community. The Education for All Handicapped Children Act, known as the EHA of 1975, is now known as IDEA from 1990 forward. Prior to the EHA, many individuals lived in state institutions with limited access to food and clothing, and their families were left out of planning and placement decisions. The EHA introduced individualized education programs, IEPs, FAPE, and the least restrictive environment for students, LRE. This extends access to a meaningful education to all students with disabilities. It also provided 1 free meal a day and improved instructional materials. Another influential case was Hendrick Hudson Central School District of Education versus Rowley in 1983. In this case, Amy Rowley, a deaf child who performed at a higher level than her peers while using an FM hearing aid, was granted a sign language interpreter. This case grants students with disabilities support with both staffing and assistive tech. This was further progressed in 1998 with the Assistive Technology Act. It made it illegal to separate children in wheelchairs or other assistive equipment from their peers who did not use that technology.
The Education for All Handicapped Children Act of 1975 was reauthorized in 1986, and this added early intervention to children with disabilities before the age of 3. This also mandated services to families of children born with disabilities, so it started to include just not the child, but also the family as well. The Handicapped Children's Protection Act of 1986 extended further parental involvement in that IEP process and also provided the right to a hearing of the state education department if they did find that their child's IEP was inappropriate. It also provided non-discriminatory access to both food and education programs. And then later in 1990, autism and TBIs were added to eligible disabilities lists. In 1988, the case of Honig versus Doe was very important because a California school board was found to have violated EHA when a student was indefinitely suspended for violent and disruptive behavior related to their disability. This was one of the first times that children with emotional disabilities were started to be included. The significance of this case was that it barred schools from suspending students with disabilities for more than 5 days when their conduct was related to their disability. And the state also was told that they must provide services directly to that student if they failed to do so. In 1987, McKinney-Vento Homeless Assistance Act was passed, and this included a continuum of care services. So these included things outside of the school as well, outside of that environment, including case management, temporary housing, supportive housing services, and one-room occupancies. And also parents could now enroll their unhoused children to go to school. Finally, in 1990, the Americans with Disabilities Act was passed, also known as ADA. This was really the culmination of all these decades of effort championing the rights of people with disabilities, which would cover now children and adults. And these anti-discrimination policies made it illegal also in the workplace past the point of school as these people entered the workforce, and people then were required to have reasonable accommodations if they had a disability. And in summary, there were great strides made from 1960 to the time period of 2000 and the passing of ADA, from a time when people with disabilities were largely excluded and coming to a point where they started to gain rights and access to their needed resources and really be included.